So let's go for an overview of the Factory Act 1948. This act, we are broadly discussing here the central part. So this after the center part, because first what happened, how these acts come into existence. So maybe now everyone is aware about how it come to the existence, but earlier many of the people don't know how it come to the existence. The government prepared their plan and their amendment if they want to, or they plan to, they want to implement a new act or new rule for that. They put their bill, the executive committee put their bill in the Lok Sabha and Rajya Sabha, then that will be passed from both the parliament houses, then it go to the approval of that President of India, then after its authorization, it will become an act. So then after, first one is the act, then relating to their, that rules are there, how that act would be come into implementation, what are the requirements under that particular act, and how that requirement should be fulfilled, and based on that, the appropriate government will decide the obligations for employer. So there are the rules. Central decide their rule according to the implementation and considering some factor related to the whole Indian scenario. Then after it go to the state government, which known as appropriate government, because the industrial, there are the central rule, central act, then connecting to this, there are the state specific rule. They amend or they draft their all rules, central rule, according to their industrial situation in their specific states. So they, if we discuss about the different forms and different type of approval are same in same state, all the states of India, but they are the form related, formal, what are the form, what are the document you have to submit for the authority for approval and procedure. Although they are same, there is a little bit of changes for that. So there the states has been, central government has given right to the state government to amend and prepare their separate state rule according to the central rules, because act will be universal for throughout India. Then there are the central rule and state rule, which are the two differentiating things which need to take care while you are working in an organization or as a freelancer or as a specialist in this service. So you have to go that time where you are going to comply under the Factory Act. So you have to consider the state rule specifically for that. But universally, you can consider the central rule, but specifically, you have to go to the state specific rule. So what say the Central Act related to factories, the Factory Act 1948, that have 11 chapters, where there are the 120 sections and 3 schedules mentioned in that. And this particular act specifically provide the provisions related to the compulsory approval, licensing and registration of factory, then the provision for the health measure, safety measure. First there is the health measure, then safety measure, then welfare measure, working hours. What should be the working hour for adult worker? Who are the adult worker? The people who, Indian citizen, male, female, anyone who has completed the age of 18, he becomes the adult worker. But who is before, below to that date, he come to the child worker or something, so he could be trained. Accordingly, there are the definition or specific definition or criteria defined for these two categories of worker and their working hours. Then employment of women and a young person, that called, which I say the child worker, that is not child worker, that is abolished here. The young person. Then the annual leave provisions are there, then accident and occupational diseases specifically. Then dangerous operation. Then there are the penalties related to the non-fulfilling of the obligations and right of employees. What are the right? What are employees' right under this? So that has been broadly mentioned under the Factories Act 1948. So this is an overview small of related to the factories, and then when you have to refer or you have to consult the Factories Act, as I mentioned previously, that you have to refer to the space specific. For references, we can utilize a central rule because act will be universally same for whole India, but the rules are state specific. So we can refer the central rule, but when we have go to the particular state, particular location, so we have to refer and consider the state specific rules for Factory Act 1948. So when we need to consult that or consider or refer the Factories Act 1948, its rule. First one is that when we are starting a factory, that is also known as greenfield project, a new premises, some organization, they need to establishment somewhere, and that time you need to refer and consider deeply the requirements or obligations under the Factories Act. What are that and how you have to comply all that. Then thereafter the another part comes throughout the life of a factory. When till the time the factory is there, till before that it does not close. So you have to refer the state specific factory rules for different approvals, different your records keeping, compliance making, and then submitting of different complying status to the authority. You need to refer the factory rules. So how it works? So there are the mostly it works on a three layer if we talk about related to the approval. So the first layer is come to the approval during the start of factory or commencement. It means when you are going to establish a greenfield, because what happened, there are the new companies or new organization are establishing, emerging, and startups are emerging in India, and then the new foreign companies are coming. So they are establishing their plants different parts of India. Accordingly, they required the people who have experience in the greenfield project. So this whole labor law specialist course will also, mastery course specifically, will help you in that also. We have designed this accordingly, how a person, he can project himself as a specialist from beginning of the greenfield project to the established organization or a plant specific or a premises specific. So I was talking here about if you have a new premises there, for that you have to start it from the base. So there you require the approvals when you are commencing the construction for that. So there your building plan, first of all, the site plan that need to be approved before going a construction for your specific premises of the factory and then factory of any company or business establishment. Then commencement of the business. Second stage come that when the commencement of business, your factory premises has been constructed. Now fully every machinery you have installed that. Now you are going to start a business, means business operation. You have started manufacturing there, so you need the approvals under the factories or director of factories. That is the state specific rules are same. The requirement will be little bit difference there, but although it will be same throughout India. So they require you the factory license. Then approval at the specific periodical renewal of factory license. So in the state specific, they have special provision. Earlier, that was only for 1 year. Every 1 year, you have to renew the factory license that will be valid for till December of that particular calendar year. But now, maximum states, they have given provisions for the factory license. You can now get the factory license approval for 1 year, 3 years, and 5 years. So accordingly, your business requirement, you can go further for that, but specific period you required a factory license. Now, this was about the second layer and the first layer, and now the second layer come in this scenario is that the facilitation of the provisions. So the facilitation of the different provision has been mentioned. So you have to comply that all the time. Even though that will be can be every day, you have to comply with. There are welfare safety provisions. Record and submission are periodical as and when required, but these two things are there which are the daily thing if you are inside the factory premises. One is the monitoring of your employees and working as per the factory requirement. Then there is safety and welfare provisions that are mandatory, which you have to comply every day. Then in the second layer, it comes to the records and the display. Then third layer comes specifically the submission, the compliance status to authorities. Means submission of the returns and other required things is not specifically to submit those requirements or some documents that are the status of your compliance with the obligation under the factory acts in your particular state for that your industry, your establishment, or your plants. So accordingly, you need to be very specific, preparing that data, filling that essential requirement, prepare that data very vigilantly, prepare that data when from the beginning when it starts according to the financial year, you have to maintain that data so that at the end you do not have to manipulate any data to make assured your compliance is 100% assured for the part of required essential statutory requirement under the Factories Act in your premises. So this is about the layer third. So there are three layers about the compliance related to the factories. So now what happened in the now come to the actual scenario of this Factories Act 1948. So when we began with this act, and specifically we should know about a little bit why this act has been enacted. So that is specifically helping the workers who are working in an organization to secure their right and major provision provided for their health and safety. That are the specifically this act was enacted. So here, if we talk about the first layer, so that are the approval, when that approval is required, as I mentioned, so that are the three specific stages where you have required to get approvals from the appropriate government. When I talk or when I pronounce, share the word of appropriate government, it means the state government specific, that is prescribed an appropriate government for each and every statutory related compliances or requirements. So here, first is the your greenfield project's approval. So greenfield project is specifically starting a premises construction required to be implemented or elected. So if we talk about that, the Factories Act 1948 specifically regulates the working condition in factories. The basic minimum requirement related to the safety, health, and welfare. These are the three major specific points of this Factory Act when it was enacted in 1948 after the Indian independence. Before that, there was the provisions of bonded labor, even though the Factories Act actually, which was based in India from derived from the Britain, that was originally enacted in 1925, and during that period, mean 1925 to 1948, there was discrimination in the industries related to the working condition of the worker of factories. So they are totally bonded. So they were not in any facility there. They were not giving some right in the factories. So they were like doing work for 24 hours, then after paying them less than, then after this act was enacted by Indian government for facilitating of the three major component or three major facilitation for the industrial worker or industry employees. So that first one is the safety, second one is the health, and third one is the welfare. Then it is applicable to all the workers. When we talk about the worker as per factories, worker means instead of occupier, all employee which are inside the premises or on the rule of the master rule of the premises, they all are the worker. Then it is applicable to all the factories who are using power and employing 10 or more workers. And if not using the power, so there the 20 and more workers are required in employment any day of the preceding 12 months, this act become applicable for that organization. So then, as I mentioned previously that, so there are special provisions has been enacted under that, so which need to take care. And further, under section 6, mandatory.
Sir,
yes.
Sir, can you explain that 10 and 20 again? Because I got 10 point, like applicable to all factories using power and employing 10 or more workers. So that is for Factories Act 1948, it is applicable if you are having 10 or more workers.
Yes.
And if not using power, employing 20 or more workers on any day of the preceding month. Can you elaborate exactly on this last line, if not onwards?
What happened? Actually, in the context of that time, many manufacturing, because when we talk about the factory process of there may be any assembling process, where that time they were manual working most of the time. So they do most of the activities manually, processing something that was manually only. So that's why there is some BD processing. So that does not require any power, and that there are many processing that come also under factories, so they require the 20 number of minimum members. But most of the in manufacturing, there are some electronics, some other, so we are mostly using the power, even that is the electrical power and other powers, to do our processing for manufacturing processing for any specific product. So it is applicable for minimum 10 employee or worker employing in the preceding 12 months.
Okay, so basically it is related to electrical power.
Yes, because power means when we are using for, if there is hydraulic power, we are also using that, but there are basic on the electricity also. So power means electricity power when we, because during the time of 1948, the big industry who has too much money, so they using the power, but most of the small area, they would no power. That time, they are using the assembling activity manually. If there are two people, as of now, one machine can do a work, perform a work of 10 people, one machine. But during that time, there were 20 people for doing an activity of one people. So that's why it was considering that. But nowadays, mandatory, not mandatory, practically all the organization, they are using the power for their manufacturing processes so that it come to applicable for that employee, they are engaging 10 and 10 plus for any days preceding 12 months. So maybe
Okay,
it is
sir,
clear to you now. Yes, please.
Yeah, I got it. Just need one clarification also on the previous point applicable to all workers. So somebody who is a supervisor, plant manager, or welfare officer, are they coming under the preview of workers, or they are not workers but they are called as employees?
If I specifically go to the Factories Act or before that new act. So that's why when the new labor code, when we connect it with the scenario of new labor code, so in the new labor code, they have given the specific definition for the employees, gig employees, and the specifically. But earlier, everyone, instead of the occupier, everyone come the work category of, not category, the definition of worker, even that is the your factory manager who has been appointed by the occupier. All that come under the definition of workers as per the Factory Act. It was mentioned in that specifically. That's why the new reforms, yes, the new reform come in the, when we will cover the new labor codes, then it will be definitely come to the purview of ours, and you will be totally clarified that why they require to give the definition worker separate and employee separate. So that was the reason. Okay, now let's go forward or further. So, as I mentioned that when you need to refer the Factories Act 1948, so there are the two reasons and the two specific areas. Number one is when you start a factory premises, their construction, and the second one is throughout the life of factories. You have to consider or refer the Factory Act during the occasionally periodical and day-to-day activities. So, most probably, what are the important things as a labor law compliance specialist need to consider while he is taking care of the compliance for a factory? That are the obligations. So, as per the factory, there are many obligations, offenses, and penalties prescribed for the different non-fulfillment of the obligations under the Factories Act. Like if there is a contravention of the provision of the Act and their rule, so there is a provision imprisonment of 2 years and fine up to 1 lakh rupees. Otherwise, both according to it will be decided by the appropriate government, or when it comes to the purview of their industrial code, and then the on continuation of the contribution. If the contravention is the continue, that is a one-time continue, then there are additional 1,000 per day the penalty of fine has been prescribed in the Factories Act. Then on the contravention of specifically Chapter 4 pertaining of the safety or dangerous operation, then there will be not less than 25,000 in case of some death happen in your premises, and not less than 5,000 in case of serious injuries happen. Then the subsequent breaching or contravention of some provisions of the Factory Act, there are the provisions of the imprisonment up to 3 years or fine minimum 10,000. That may also be exceeded up till 2 lakh rupees. It will be based on the actual scenario or actual situation, and when it comes to the actual accounting of the contravention of specific regulation or provision under the Factories Act or the specific rules. Then if you obstruct any inspector coming to in your premises and then going for an inspection, that is also an obligation and offense under the Factories Act, where the provision of imprisonment 6 months and fine up to 10,000, and both can be imposed on employer if you obstruct the inspector to inspecting your premises, or if there is some wrongful disclosure result pertaining to the result of analysis. Means when you submit any returns, you submit some data, and when they inspect that data has been something different from you presented, so that time that is also a contravention or an offense under the Factories Act. So for that, they are the provisions of imprisonment 6 months and fine up till 10,000 rupees. Otherwise, that both can be imposed to the employer, which you need to take care. Then for the contravention of the prevention, specifically the provision number 41B, C, and H pertaining to the compulsory disclosure of information by occupier, specific responsibility of occupier or right of the workers to work imminent danger. So that is the one specific three clause or section there, 41B, C, and H, where you as a specialist of the labor law compliance you need to consider. Under that, there are the provisions of imprisonment up till 7 years and fine up to 2 lakh rupees. And if that is continuous, so there is a provision of fine 5,000 rupees per day, which will impact an employer both one financially and secondly their image. So as a specialist, mostly who is the people in labor law compliance specialization, he should mostly focus on the obligations. When you focus on the obligation, then automatically your layer for connecting to the other compliances, it will automatically down. Like safety provision, health provision, and welfare. Three are the major provisions which will become in connection with the, if there are obligation, contravention of these three specific areas, so it leads to the imprisonment, financial impact, and the image impact of your employer. So that's why you need to take care the obligation under these Pay Act, which we have prepared for you, so that I'm sharing with you. So that is a small booklet, means 2 pages for you, which you can go through anytime. You can keep it on your mobile also. So whenever it's required, you can refer this to. Further that, as previously I have mentioned that there are some specific websites who are previously providing the references of their acts very simply and a very specific way where you can learn, that are the like advocate course and then simply compliance, other that we will share with you when this data come to you into the mail, or otherwise when you will get the access to our digital institution. So all that accessible or all that data and the references you will get there for your references for the future. So if we talk about the working hours, spread over and overtime, so that are the specific provision under the Factories Act 1948. So the weekly hour that has been made provision of the 48 hours for a week. So there are the provision of the 6-day working according to the Factories Act and 1 hour each day. So the total, it should be 48 hours in the day. So then there are the daily hours. It should not be more than 9 hours. As a labor law compliance specialist, you need to be considered here. If you are not paying any overtime, there is a provision of overtime also, but if you are not paying any overtime to employee, he should not be available in your premises more than 9 hours. So as per Factory Act, it is considered up till 9 hours. If he or she stay in your premises more than 9 hours, so you have to pay him or her overtime double of his ordinary wage. Then there are the provisions of the interval for rest, at least half hours on working in 5 hours. Interval you can consider it as lunchtime also. So there is a half-hour interval that required within 5 hours you have to give to your employees who are working in your organization. Then the maximum spread over time, not more than 10-30 hours in a day. So legally, when there are, when we talk about the overtime also, what it should be, it would be for a day 20 hour, 20, sorry, not 20, 2.5 hour legally. So that's why it go for the near about a month. So then overlapping shift prohibited. So there should not be any overlapping shift for. So if your organization, there are the shift provision, so that should not be overlapped. So you have to, if you are, when you know about the labor requirements, then there are the provisions in the organization. They have the working in the shifts. In many organizations, they are working in 24 hours scenario, and some they working in the 14-hour, or some they work in the 16-hour two shifts. So accordingly, when there are shift system, there should not be any shift overlapped to the another. So that you need to be take care when you design the shift system for your organization. So it should be 8 hour, 8 hour, 8 hour not specifically working, but it should be come in, then in the interval time should be there. So accordingly, you have to decide your shifts for your employee. Then we talk about the employment of a young person, where the provision has been made under this specific act. So that are the prohibition of employment of young children, means who are 14-year-old, they do not require to work in the organization. So that's why there are, maybe you have seen that many organizations, they have specific display over their entry gate, person age below 18 not allowed to enter in the premises. So that is specifically the fulfilling the obligation of this specific regulation under the Factories Act, where the employment of young children below 14 years are not required. But after 14 to 18, they can be only the trainees, and their time period should be specific, which has been specified in the Factories Act and in their rules. So then the non-adult worker to carry token or certificate of fitness, means if you are engaging any training who are not adult worker, means who are not more than 18 years of age, they should carry a certificate of fitness. We will also share who will provide this certificate. So that is the certified surgeon in every state. So they need to get the fitness certificate from the certified surgeon. To that certificate they need to carry with them. They can enter in your premises. Then come to the working hours for the children, not more than 4.5 hours, means 4.5 hours, and not permitted to work during the night shift. Then the overlapping shift is same, not allowed. Yes.
Sir, sorry to disturb you. Here it has been mentioning that children are not allowed to work for more than 4.5 hours. But if we are prohibiting the employment of children only, sir, then how there is contradiction in the statement, sir?
This is not children, it is writing here as children. It is for the non-adult worker, means who are the 15 to 18 years.
Means, sir, adolescents you are talking about, sir?
Yeah. Because here yes. So children, it is mentioned only here, because who is right there, so may be mentioned accordingly. But there, the non-adult worker means who are adolescents, who are 15 to 18 years. So their time for the working in your premises with carrying of the fitness certificate, that will be 4.5 hours, and they cannot be work during the night shift. It is mentioned or provision has been made in the Factories Act 1948. Then accordingly, overlapping is not allowed anywhere, even that is your aged worker, or even that is for your adolescents or the non-adult workers. Then we go for the annual leave, for which there are the provision mentioned in the Factories Act 1948. So they are a worker who have worked for 240 days. According to that, he need to give the 20 days of annual leave with wage, and for child that should be means 20-day one leave, and for child or the adolescent worker who may be your training or something, then that should be 15 days calculated based on the 15, and this is the calculation for the annual leave.
Sir, here adolescent.
Yeah, that is where I mentioned, where you can see in that children, so that is for adolescents. I'm clearing it here that when I say that children is not allowed there, that is the adolescent person who is under the age of 15 to 18. So that provision has for those people, because the children who are below age of 14, they are not allowed to work in the any premises or any factory, according to the Factories Act 1948.
Sir, one more query I want to ask you, sir.
Okay.
Sir, in the whole Factory Act, sir, there is nothing spoken about the weekly off, whether it's paid weekly off or without paid weekly off. Like,
if you say accordingly weekly off, paid or not paid,
yes,
it
sir.
is not mentioned there. So that is only mentioned that you need to give 1 day rest. Because
Yes, sir. That is
yes, when it in Factory Act,
whether we have to pay it or we don't have to pay it, sir.
but it is not because you are paying it or not paying. Question is that when you go for the minimum wage, so according to
Yes,
the
sir.
minimum wage, that is specifically some state given the provision that is calculated on 30 days, that is calculated on 26 days.
Yes,
If
sir.
you are calculating the wage specifically on 26 days, so you are paying, if your wage is, you understand it from me, your wage is 15,000 rupees. Okay, you
Yes,
are
sir.
calculating that on 26 days. So there you are not paying to the rest day. If you are calculating on 30 days, you are paying that. But finally, it is still the contradiction that it is not mentioned that the off day you need to be paid or not to be paid. So as per the Payment of Wage Act, so it come as the you have to pay it or not. Specifically, there is a payment dues when you calculate it from specific. If you go as per the Factory Act or the some other law, so that required the 26 days. So that time you do know that consider that you do not paying for the rest day for an employee or the worker. But and it come to the payment of wage, so there is mentioned you have to pay to according to their calendar days. So when it comes to the contradiction again that 30 days they have to pay. So specifically, when we are the compliance people, so we need to consider that because the law specifically, sometimes there are too much loopholes. So accordingly, then the new labor codes are coming. So they have briefly defined that. We will discuss it later on during that specific segment. So it will become to finalize to understanding specifically what we have to do. Actually, the payment you are paying to them, that is basis on the 26 days.
Then,
Because,
sir, we have a problem for maintaining register musters, nothing. Because the same muster we have to produce the factory inspector and the same muster we have to produce the labor inspector, sir.
Yes.
Then how we have to adjust, like whether here it is in Factories Act, it is without pay, and in when we talk of minimum wages or payment of wages,
that will be paid.
Yes, sir.
Yeah, so
then
that's
how we have
so
to
that's why I'm saying that when you are a compliance person, you have to consider according to the wage, because so that's why when we discuss about the new labor code, so there are one uniform definition for which earlier there were different definitions. So accordingly, the same thing is happening here. That's why when you consider, you need to consider the whole, because actually the amount you are paying to same that if you calculate it based on 26, if you are calculating on the calendar month, so that will be
Yes,
amount
sir.
will be same. So consider for compliance purpose the calendar month. Do not consider 26 days and 4 rest day without pay. So consider it for the calendar according to the calendar month. So even that there are 30 days or there are 31 days according to that. So it will be for compliance purpose. It will be okay, but factory inspector will not question on that.
Okay, sir.
Yeah. So in that case, you need to consider as per the calendar too. Because factory do not consider or do not monitoring the payment. They only monitoring the working. So for that, what you are paying to them, when they question about what you are paying to them, then they refer to the payment of wage act and minimum of wage act. That's why you need to consider those when you apply related to the factory. So that's why the new labor acts or labor codes has been enacted and merged many of the labor law in those acts to give the ease of businesses and ease of working and clear understanding about this, because the previous existing labor laws there many of the definition, many of the things are not clear. It is totally based on the interpretation. If there is some case happen somewhere in Bombay, then High Court or the State Court give the decision on that. Accordingly, that interpretation will be applicable throughout the India where the act is applicable. But now, in the new labor codes, that has been clarified very specifically by the government. So they have taken care all these things in preparing of these new acts. So we will discuss that later on in the new segmentation. So is it okay to you? Thank you so much.
Yes,
so
sir.
now,
Yes, sir. Thank you, sir. Thank you.
Okay.
Sir, I have a question. This certificate of fitness from doctor, is it from any practitioner doctor or only doctors appointed by the factory?
Specifically, when required under the Factories Act. Otherwise, Factory Acts also say that it should be the MBBS. He can also give that, but there are the certified surgeon every state level or for every industrial sector. So that need to be required for them. But there are new amendment that comes after later on. So it is okay when the certificate would be from a MBBS doctor, but not less than that.
No, correct. But any MBBS doctor is okay.
Yes,
right?
yes. Any means who is a general physician, who is a
yeah, correct.
General physician only, not from the person is the surgical specialist. So he cannot be only for the general physician. Goes the certified surgeon would be only that general physician.
Yes, and no required only. See, factory may have some 4 doctors already appointed, or they have on their panel, but it is not required that the person, the adolescent between age of 15 to 18, take only from them. He can bring from any practicing physician.
No, you don't have to bring for that, because when you are engaging that person first time, so that time there is a specific requirement. He need to that certificate. Although for the provision of compliances that your factory doctor can be, because that factory doctor, he has a specific registration from the medical association, India level, but he do not have from your factories. So that's why he can also do that. But actually, as per the compliances, and it's mandatory, from the first time when you are engaging that person, he needs to that certificate from the, even though that is a certified that.
So you meant to say at the time of appointment, factory doctor, if he's there, his certificate is okay. So at what interval this certificate is required? In the sense, is it required every year or every 3 years, or how is it?
Specifically, what the specific mean? 15 to 18 years, he would not be worker, he would be a trainee. So your training is only for the 1 year and 2 years. This certificate required to revise every 6 months. You need to update that in every 6 months, because there is some specific disease in the body or some specific changes in the body that required 6 months as per the medical requirement and as per the other requirements. So every 6 months, that certificate need to be, means that a person needs to be specifically rescreened by his specific doctor, or he can that revise that accordingly.
Okay.
Minimum. It is not that is required only. It is minimum 6 months. So after that, it will be 1 year mandatory. After 1 year, you need to be review that certificate, or accordingly, the certificate where to needs generate, because there is a limitation for a disease to increasing. So that is a minimum 6 months required if there is any change in the body. Okay, is it okay now?
Okay. Yeah.
Thank you. So let's move further. Yes, please.
Sir, there is some concept called medical fitness checkup for all the employees, which has to be done every year.
Yes. So that earlier there was some. Now, if you go to the previous cases, so that was mandatory for critical. Like you have some critical operations there, and some machines where your throat, your ear, then your lungs, you need to be checked that every 6 months or 1 year. Now, the labor codes, it has been made provision under that every year. The organization, they need to provide the health checkup for their employee annually. But as of now, in the existing case, it is for the critical. Where you have the critical operation, like there is some smoke is available, then there is some that furnace is there, then your canteen is
hazardous
there.
process like.
Yes, hazard process, you can say that. So there you required that every 6 months you need to examine that. And now new provision as per the new labor code, so that you have to mandatory that give the health checkup or provide the health checkup to your employee, your worker annually. That has been become mandatory in that. When these new acts will implement from 1st October, so it will become mandatory for the organization to, they need to implement that. Is it clear now?
Yes, sir. Yes, sir. Thank you, sir.
Okay, welcome. So now let's go to the fencing, means where specifically there are some moving machinery available which are in motion. So there the specific requirement related to the safety provision has been made under the Factories Act 1948. So the employment prohibited of young person means adolescents that should not be in these dangerous areas. Then striking gears and devices for cutting of power that should be fully covered. So this type of provision has been made there. Then come to the welfare measures. So related to the washing facility should be there. The facility for storing and drying clothes provision has been made under the Factories Act. Then sitting, first aid appliances, and one first aid box. If there the manpower, you have strength 150, so you have to maintain at least one first aid appliance or first aid box in the organization. Then canteen, when there are 250 and more worker, then shelter and restroom, lunchroom, when there are 150 and more worker available, then a crèche facility if there are 30 women working in your welfare officer, if there are the 500. So such type of provision has been made specifically covering the three major component under the Factories Act, that are the safety, health and welfare of your, even you can say the worker, even that you can say them the employees. So that are applicable to all the workers. When as per the Factory Act, worker means instead of occupier, all employees, every person who is working in your premises, that person, they are the workers. That is the definition of Factories Act 1948 related to factories. So yes, please.
Sir, even the housekeeping person and security person will be counted in the number of their employees, the 10, 20 numbers which has been mentioned above, for calculating the strength of the employees?
Yes, of course.
For the coverage of under Factories Act, you have mentioned like with aid of power 10 number and without aid of power 20 number of employees. If there are housekeeping persons and securities, so they all will be covered, counted for coverage under Factories Act?
No, no, no. Or when you are going to coverage for Factory Act, it should be on your muster roll.
Okay, no, so like I'm having I'm having, you can say 5 workers on my muster roll, and it's running with the aid of power.
Yes.
Then I am having 4 security guards. They are on contract, and 2 are housekeeping guys who are on what we say company's roll. So that comes total comes to 10. Then whether
who are on company roll?
5 employees are on the company roll, and you can say 2 housekeeping persons are on the company roll, and rest are on the rest are security guards. So like I have to count the security guard for total of 10 strength or not?
No, no, no. For when we go for the factory, because one contractor you have specifically registration required under the Contractor Regulation Act. For factory purpose, you need to 10 employees. If you cannot, but as for Factory Act, every person who are employing in your organization on your muster roll, instead of the occupier, they are come under the definition of worker. So all those people who are in your your muster roll that are employed, that required 10. When that are 10, the Factory Act will be applicable to your organization. But before that, it would not be. When you are engaging some security person, they are from other people and from other vendors or agencies, so that not considered for you for the purpose of factory applicability.
Coverage.
Yeah, coverage
Okay,
or
sir.
applicability.
Yeah, fine, sir, fine.
Okay, thank you. And then go to the some returns and the maintaining of specific returns or submitting of return under the Factories Act. So there are the annual return and half yearly return, then list of holidays, and then the one specific thing that the accidental report and accidental return annually you need to submit.